Greetings and welcome to our LLB Law Lecture Series for Company Law Unit. My name is Ayub Okayo, and today I'll be taking you through part one of Company Law, which will cover an introduction to company law, the history of companies, and finally, classification of those companies. But before we explore our today's topic, let us quickly highlight some of the major topics that this company law unit will cover in this module. Under this unit, we shall learn about types of companies, its formation, alteration of company status, company membership, directors of a company, how they're appointed, their duties and responsibilities, company meetings, the resolutions that come from those meetings, company shares, and finally, we shall look at how a company is wound up. So, welcome. Let us now explore our first topic on introduction to company law. So, what is a company? Section 3 of Companies Act of 2015 defines a company as that body corporate formed and registered under the Act or an existing company. And the same Section 3 looks at an existing company as that company which was registered under the repealed Companies Act or ordinances. Although it does not offer specifics of what a company entails, it only provides us with where the criteria for formation of the company is found. In case law, Barclay J. in Re Stanley 1906 notes that a company is that body or association of persons who contribute money or money's worth to a common stock and who employs it to a common purpose. Although Barclay J does not distinguish a company from partnership because partnership equally requires contribution of money or equity towards that common purpose, he fails to distinguish the two business models. Under the common law, a company is considered as a separate legal person and it is perpetual in its existence. That means even at the death of a member, a company cannot die. Now, let us look at the background of companies. How did the companies come to an existence as a corporate body or a separate legal person from its own owners? These companies, the companies originate from the English merchants who are trading in clothes and several goods, especially at the overseas. They required a large amount of money for investment and also a large scale production to satisfy the market demand. And as a result, it raised a need for contributing large capital towards the operation of that kind of business. And that is how the companies came to be formed as a separate body from its own members. They needed to limit the abilities of those who were investing in those businesses. It was also one of those driving factors that created companies to shield liabilities from those members who come together to contribute towards the capital investment of that uh, kind of business. So there are two major things that brought up the company: need for large scale investment. So a lot of money was required to pull together. Members were to contribute towards that. And second, to shield the liabilities of whatever happens in the company, it should not be part of the owners of that company. Now, there are two major founding principles of the company law, and these principles include one, legal or corporate personality, and two, limited liability. So let us look at first, legal or corporate personality. When we say a company is a legal or a corporate personality or a juridical person, it means that a company is subject to obligations, it has its own rights, and its duties. So the company can sue or be sued and is completely separate from its own members. These principles first formulated in the Solomon versus Solomon case of 1897, which I encourage you to read. The company is at law different person altogether from its subscribers. So if I subscribe towards the operation of a company, I am separate from the company itself. So the company exists on its own name. It can sue, it can be sued, it can own property separately, and it also has its own obligation that it must fulfill. Failure to which it can be sued by by someone if it's at fault on violating of another's rights. So it goes without saying that a legal person distinct from its members means that the members of this company who have contributed towards the capital of that company, they are not part and parcel of the company itself, because the company is an standalone person. So in case it has done wrong, they are not going to drag in a shareholder and sue the shareholder on behalf of the company, but rather they will sue the company if the company is at fault. The principle of legal and corporate personality is also affirmed in Section 19 of Companies Act of Kenya, and it notes that from the date of incorporation, once the company has been brought to an existence, it is now becomes a body corporate, and that means it has its own independence. It can sue, be sued, own property, have rights and obligations. Now, let us look at the second principle, which is the limited liability theory. So, the limited liability theory is that particular theory that denotes that the membership of the membership of a company is limited to the capital, either paid or unpaid capital towards the subscription of that company in case of insolvency or winding up. So if a member has contributed their capital towards a company, in the event that a company is being wound up, their assets will be shielded from any debts that a company has accrued only to the extent of their capital contribution. So if anything goes beyond their capital contribution, then they will be limited, unless a company is an unlimited company. So a limited company can be in two major folds, either limited by shares or limited by guarantee. If it's limited by shares, the articles of that particular company will specifically indicate that this company is limited by shares, and it goes to the extent of unpaid shares held by a particular member. So let's say your paid up shares is up to 10,000, and then unpaid is up to 15,000. So in total, you will be liable for 25,000. in total towards the liability of that company in case of insolvency or winding up. Now, what about the limited liability by guarantee? So, under this, the articles of association will indicate the amount each member has guaranteed that in case a company is wound up, they are they are they have guaranteed to remit or to contribute towards the liability of a company. So it will be by way of guaranteeing that if this company goes insolvent, then I will contribute 1 million Kenyan shillings towards the fulfillment of the liabilities of that company or the debts of that company. So that guarantee, it's to that extent that it has been given. So that guarantee cannot be beyond what a member has guaranteed the company in case of winding up. Now, let us now look at the types of companies that exist. There are several types of companies that exist, and some of these are just different fashions of a corporations or companies, how they uh, they they are composed. So we have a corporation soul, a legal formed corporation in terms of a corporate soul, we is that that established office that is distinct from the holder and can only be occupied by one person, after which he is succeeded by another. So it's just accompanied by one person that is run. And then, in case that person is no more, especially the family related companies, where it has only a sole owner, then that company, in case of the owner dies, the company can move to the next of kin of that particular person. We also have corporation aggregate, which is a legal entity formed by two or more persons for a lawful purpose and whose membership consists of at least two persons. So you have those companies that have more than two members or two owners who come together to form that particular company. So that will be called a corporation aggregate. Then we have statutory corporations. These ones come into existence through an act of parliament. Section 3(1) of the State Corporations Act, Cap 446, looks at um, looks at the structure of a company formed as a statutory corporation, and it provides for how such kind of company can be formed. But mostly they are brought into an existence through an act of parliament. It has no shareholders, and its initial capital is always donated or given by the treasury of the country. So it has no shareholders. So you have those corporations that operate on its own, and they operate as any other corporation, but these kind of corporations, they are brought into existence through an act of parliament, and they have no shareholders except reliance on the treasury. Then we have the chartered corporations like institutions of higher learning, universities, which they are given a charter to operate as authoritative institutions, and the corporations are always governed or managed by the the charter itself. So let us now look at the classification of companies under the Companies Act. There are several of these classifications on how a company can be classified. So we have a limited company. What is this? Section 5 of the Companies Act provides for a limited company which is by either guarantee or by their shareholders, as we've already looked at in our previous slide. Now, if it's limited by the shareholding, it means a member who have subscribed towards the capital of that particular company will only be limited to the extent to which they have subscribed to the shareholding, either paid up or unpaid up capital. Anything beyond that, in case of insolvency or winding up of a company, then the shareholders are shielded. So they are protected from um, their personal assets cannot be attracted to fulfill an obligation or liability of a company in case the assets of the company are insufficient to fulfill the debts of that particular company. So the members of that company will be protected, and only liability that will be absorbed from them will be limited to what they have contributed in terms of shareholding. So either paid up or unpaid up share capital, shares towards the capital of that particular business. If it's guarantee, if it's limited by guarantee, it's only to the extent to which a company has um, been, a member has guaranteed that they will um, absorb the liability of a company to a certain extent. As I gave an example in a previous slide, that if one has guaranteed the company to 1 million of debt burden, then if a company is being wound up, they are only liable to that extent of what they have guaranteed that they will provide towards the capital, towards the debt of that company. So anything beyond that, it will not be, um, the owners of the company will be protected. And Section 6 of the Companies Act provides that a company limited by shareholder will be that the Articles of Association provides that the company is formed by way of limited shareholding. So the Article of Association will show that. The same as Section 7, which indicates that a company is limited by guarantee if it does not have the share capital, and then the liability of its members is only limited to the extent of the um, company's amount that the members undertake to contribute towards the asset of that particular company in event of winding up. Also, if a company is limited by guarantee, then its certificate of incorporation will state that that particular company is limited by guarantee. What about unlimited company? This type of company is provided under Section 8 of the Companies Act, and it has an effect of absorbing the company's debt beyond the subscription of members toward the capital of that business. That means that members are not protected from liabilities of a company only to what they contributed. So, in case a company is being wound up and the debts of their creditors has not been met by the company assets, the the, uh, the, the creditors can absorb the remaining amount from the shareholders. So the shareholders' personal assets can be absorbed to meet the debts or liabilities of that particular company. So there is no limit to the liability of members, and the certificate of incorporation of that particular company it also indicates that such company is unlimited. Now, Section 9 of the Companies Act provides for the private companies. Now we have the private companies and public companies. The private companies, um, the articles of association restrict the members who can join these particular companies. Because the shareholding of the private companies is not freely transferable to other members. So its articles restrict members' rights to transfer their shares to outside parties. And also, private companies um, has the limit number of the members to up to 50. They cannot go beyond 50 in number, as opposed to public company, which has no limit with regards to the membership. We also have to understand that in the event that a new member is being added, articles of association may require that the other members who are existing in that particular company gives a consent to adopt or to bring in a new member into that particular company. And of course, the certificate of incorporation of a private company will state that this is a private company at the time when this company is being formed. Now, what about a public company? Section 10 of the Public Companies Act provides that a public company has the members of the public company rather have the right to freely transfer their shares within the company. So they can sell their shares to anyone in in the event that they want to exit the company. So the shares of a public company are always freely transferable. Most of these public companies are listed at the Nairobi Stock Exchange market, and that is where the shares will freely be transferred from one person to another when they are floated for any interested buyer. So someone who wish to join the company, and then they can always go to Nairobi Stock Exchange market for the public company that are listed, and then they can buy the shares and become part of the company. Also, the public companies, when registering, its articles of association must clearly indicate that this is a public company and the members have subscribed toward the shareholding of that particular company in terms of shares or debentures of that company. So they can float the debt capital or equity capital. So the equity capital will be the shares and the debt capital will be the debentures where they're inviting for creditors to um, to bring in the money for the operation of the company. Other than that, public company also has the limitation that um, there must have at least two directors. And at the time when directors are being appointed, at least one of those directors must be a natural person. Also, it's important for us to understand that at the time of incorporation, the certificate of incorporation must state that this is a public company which is being incorporated. Now, let us look at the holding company and subsidiary companies. So here, the shareholders put their equity into one company, which is called the holding company. And then this company will now invest in different smaller companies which are called subsidiaries. So subsidiary companies are always under a holding company which has the following characteristics as per the Section 3 of Companies Act, which note that the holding company controls the composition of that um, company's body or board of directors. So they appoint and they control the board of directors of those subsidiary companies. So they also um, hold more than half of the voting rights. And that's the only way they can have the control on the board. So they always have more than 50 plus one vote to make decisions within that particular subsidiary. Of course, some subsidiaries may be wholly owned subsidiaries by the holding company, or they may be partly owned by the holding company and also by another or by themselves as subsidiary companies. Um, if or in the event that it's more than half owned in terms of the share capital, then the holding company will only have the majority voting stake. But there are some decisions that may require not just 50 plus 1% or 50 plus 1 vote. Um, they may require some resolutions, as we will see in our other chapter when we'll be looking at the company meeting and resolutions, that some resolutions require at least 75% of votes. So, in the event that this is not a wholly owned subsidiary, then there can still be a holding company that may not have the total control over a subsidiary. Now, what about subsidiary company? Section 3 of Companies Act provides that a subsidiary company is that company which is under the holding company. So it does not really say much about what a subsidiary company is, but as I've explained, the holding company will invest in subsidiary company, and it depends on the amount of investment in that company that will exert the control of that subsidiary. So if it's a wholly owned subsidiary, it means it's 100% um, share owned or capital or share capital owned by the holding company. So that means they can always change the director the way they want. They can always vote for any resolution and pass it the way they want. Now, let us now look at the distinction between a company and other forms of business. So the first distinction, we're looking at the formation. A company is always formed through the registration of companies pursuant to the Companies Act. We will look at the registration of company, formation of the company in the next chapter. While the sole proprietorship, there is normally um, registration of this kind of business is governed under the Business Name Act, CAP 499. And then with the general partnership, it's regulated by they are regulated by the Partnership Act. Either they are limited liability partnership or not limited liability partnership, which is unlimited. The number of shareholding a company depends. If it's a public company, it has no maximum number of shareholding, but it will have a minimum number of two, one or more, if it's a private company. And if it's a sole company, it only has one person running that kind of business. And if it's a general partnership, then it has to have at least two or more members. Liability of its own members for a company, it depends. It might be limited liability or unlimited liability for a company. For a sole proprietorship, it's unlimited. In case of a debt accrued by a business which is a sole proprietorship, then the liability of that particular business can be absorbed from the personal assets of that sole proprietor. And the same happens to partnership. If it's a limited liability partnership, then it will shield their partners. And if it's unlimited liability partnership, then those liabilities will still overflow towards the the members of that partnership. Then profit distribution. For a company, we distribute profit through dividends, and that goes to all the shareholders, and it depends on the preferences of the shareholder. We look at this when we're looking at the types of the shares. If it's for the sole proprietors, of course the money goes directly to them, no division of the profits that come from their business. But with regards to the general partnership, mostly they share profits on a specific ratio as agreed before the formation of a partnership in a document which we call the partnership deed. Now, what about the continuity of these business forms? With regards to the company, it has perpetual ownership, perpetual succession. In the event that one subscriber dies, the company continues to exist, as opposed to a sole proprietor. If they die, then that business is likely to die with them. And for partnership, in case of a death of one of the members of that general partnership, then that partnership will be dissolved, and um, and there will be no continuation of that partnership because it has to regroup itself. So that's it for the part one of this lecture series for company law. Next topic, we'll be looking at the formation of companies. Thank you very much and see you in the next lecture.